So your parent passed away, the house is part of the estate, and one of your siblings, or maybe even your own parent's partner, is still living there. And now everyone's asking the same uncomfortable question, and nobody wants to be the one who has to answer it. The situation comes up more than most families realize, and it creates some of the most complicated, emotionally charged conversations I have seen in my work. Because the answer isn't simple, and it depends on a few important factors that most people don't know about until they're already in the middle of the conflict. If you're dealing with this right now, whether you're the one living in the property or you're an heir trying to figure out what you can actually do, stay with me because I'm going to walk you through exactly what the law says, what the options are, and how families typically navigate this. The situation comes up more than most families expect, and it creates some of the most complicated, emotionally charged conversations I've ever seen in real estate. So let's walk through exactly what your options are, what the law actually says in California, and how families usually find a way through it. Before we talk about rights and options, it's worth understanding that an heir living in the property can mean a few different things, and which one applies to your family completely changes how this plays out. Scenario one, the adult child moved back in to care for an aging parent and is still living there after the parent's death. Scenario two, a sibling who was already living in the home, maybe they never left, or maybe they moved in years ago and now they're refusing to leave or cooperate with the estate process. Scenario three, a spouse or domestic partner who lived there with your parent and who now has a claim to stay, sometimes even a legal right to do so. These are three very different situations, and I'll touch on all of them. The biggest source of conflict I see is scenario two, the sibling situation. So let's spend the most time there. Here's an analogy that makes this click for most people. Think of an inherited property like a pie. If there are three heirs, each of you own a slice. That's called tenancy in common in California. And here's the important part. No single slice holder can lock the other slice out. Under California law, each heir as a co-owner has what's called the right of possession. That means any heir technically has a right to occupy the property, but so does every other heir. So the sibling living in the house isn't doing anything technically illegal just by being there. They have an ownership interest too. But, and this is where it gets complicated, that doesn't mean they get to live there for free indefinitely while blocking a sale. This comes up constantly, so let's be clear. In California, when one co-owner occupies the property and the others don't, the occupying heir can be required to pay rent. But it's not automatic. It typically requires either a written agreement between the heirs or a court order. This legal term of rent credit is ouster, meaning that other heirs have been effectively pushed out of the property they own. If one heir is living there and actively blocking the others from using it, that's ouster, and the courts can require compensation. But here's the practical reality. Most families don't want to file a motion in probate court over rent. It's expensive, it takes time, and it almost always poisons whatever family relationship is left. What I usually see work better is a direct conversation with clear documentation, a written agreement about the timeline, any occupancy costs, and what happens when the property sells. Your probate attorney can help draft that. This is where the situation escalates. And unfortunately, this does happen. The most powerful legal tool available to the other heirs is something called a partition action. Think of it as a court forcing the split of the pie. In California, partition action allows co-owners to force the sale of the property when the parties can't agree. It's not a fast process. It can take months, sometimes over a year, but it's real and courts do grant them, particularly when one heir is blocking a sale that the majority of heirs want to proceed with. The threat of partition is often what finally moves things forward without actually having to file. Now, if the property is in a trust, which is very common in California, the trustee has broader authority. A trustee can actually initiate an eviction of an occupying heir if the trust document gives them that power. That's something to confirm directly with the trust attorney. And if the estate is going through formal probate, the court appointed administrator or executor may also have authority to remove occupants. Again, that's something the attorney handles, not me. This one deserves its own mention because families are often blindsided by it. California law provides what's called a right of family allowance and sometimes a probate homestead, which can give a surviving spouse or a registered domestic partner the legal right to remain in the home for a period of time, even during probate. Beyond that, if the partner isn't married but had a long-term residency in the home, an eviction through normal channels may still be required, meaning you can't just ask them to leave and expect it to happen overnight. This is a situation where you absolutely want a probate attorney involved before you do anything else. I've seen families try to handle this on their own and create legal exposure they weren't expecting. Here's what I see work most often when one heir is living in the property and a sale is needed. 1. Get everyone on the same page early. The longer the occupying heir is in the home without a clear exit plan, the harder it becomes to establish a timeline in writing. 2. Address the financial reality. If the occupying heir generally can't afford to move right now, explore an estate advance. A third-party company gives the heir cash based on their expected inheritance. I have a vendor that is part of my concierge service that can help. 3. Keep the property maintained and insured. This is important. If an occupying heir is living in the property and the state still needs to maintain insurance, continue property tax payments if due, and keep utilities functioning. I've seen situations where an occupied property fell into disrepair during a family standoff, and that hurts the sale price for everyone. 4. Work with a real estate professional who understands the situation. Not every agent does, but someone who specializes in estate and inherited property knows how to move carefully through this, keep the family dynamic intact where possible, and still get the property sold. If this video helped you make sense of a situation that felt really messy, and that's exactly why I made this, please share it with whoever else is navigating this alongside you, because most families don't find this information until they're already in the middle of a conflict. And if you're in Orange County and you want to talk through your specific situation, no pressure, no sales pitch. There's a link in the description to schedule a call with me directly. I'm Kathy Welmerly, and I work with families navigating inherited property in Orange County. If that's you, there's a link below. This video is for educational purposes only. Please consult a licensed attorney and CPA for legal and tax advice specific to your situation. I'll see you in the next video.